Okay, so what we're going to start with is the hearings in Judge McGee's chambers. So that's going to be me as the judge, and then Jennifer is Jerry, Laura is Mrs. Galt, Joe, Jerry's older brother. Now, Jim is not here, and I think he wasn't in. Is he in my writing class? I forget. No, he's not. We'll come back to them in a minute. Actually, Stephanie, you're here, so worst case scenario, you can function, as both in terms of the officers. That's fine.
Okay.
And then, Jonathan, you're my clerk.
Yes, ma'am.
So why don't you come over here first? I just want enough seats because we're going to do this one as if you came into my office.
Is this recording?
Yes.
Oh, it's embarrassing.
Yes. Online students are hearing this now. So you kind of tell me that the parties in the golf matter are here, and then you'll go and get them, and I'm going to actually have you guys come and sit. 1, 2, 3, 4, right? Sit, stand, whatever. You guys are my kids. Yeah, he's going to come and get you from the hallway.
Okay.
All right. All right.
I'm the son, the other son.
There goes the programs.
Oh,
Can I be a girl?
Yeah, Joe, you're Jerry's older brother. Yeah, yeah.
oh. Sorry. You're a disgrace in the
Jeez. You guys better stop by. All right. So assuming, so I'm sitting at my desk. Jonathan you're going to come in and you're going to tell me that they're here, and I'm going to tell you to go get them.
Gotcha.
And then after that, everybody's assuming their role.
Okay.
Where's my voice?
So reaction?
What's that?
Action?
Action.
Just
Say. Come on in, Jonathan.
How you doing, Judge Caldas?
Good.
The parties for the Galt matter are present.
Oh, now I was just heading out to lunch. All right, fine. Bring them in.
All right, sure. Come with me. All right. Your Honor, they're here.
All right. How are you folks all doing?
Good judge. I'm Mrs. Galt.
Hi, officer. How you doing?
My wife's.
Who do you have here?
We have here Mrs. Galt. I remember you. Jerry and the brother. And Jerry's brother.
Mm-hmm. So what's going on, officer? Why are they here?
So the reason why they're here today is because Jerry was hauled in. And because he made rude phone calls to a woman by the name of Mrs. Cook. And so because the lewd calls were very disturbing to...
Jerry, look familiar, too. He's been in my court before, right, officer?
Oh, absolutely.
Stole a wallet or something?
He stole a while ago out of someone's purse, an old lady, in fact.
Uh-huh.
And so he's been, since February, in fact, Jerry has been on probation. So within the last 6 months, he's getting in trouble now. So we kind of just took him off the streets to keep the community safe.
Mm-hmm. What did you do, Jerry?
I don't know. Something always comes over me.
Why weren't you in school? Why wasn't he in school, Mrs.
I
Galt?
don't go to school. I don't like going to school. I skip class all the time, being like that.
Really?
We just answer the judge's questions one at a time, sweetheart.
Self-incrimination of it.
I'm sorry, my husband and I were at work, and he's on summer vacation. So he was home for the day, and being 15 years old, we thought that was fine, and his older brother is around as well.
Do you watch over him?
It's hard.
How old are you?
I'm 18.
So do you go to school or work?
I work.
Where do you work?
I deliver pizza.
Okay. Yeah. Why are you here?
Well, on the day that he was taken into custody, my mother had come home and she was asking where he was, and I didn't know. You know, he's kind of hard to keep hold of. He's 15. You know, he's out with his friends, and so I went over to the Lewis's trailer. She sent me over there.
Okay.
Because, you know, they're kind of nosy. They know what's going on around the trailer park, and they told me that he was taken into detention.
And he's still there, right, officer?
Yes.
Yeah.
Yes.
You're taking him back there today,
Yes.
right? Yeah. Oh, yes, Mrs. Gall.
Even before the
That's-
hearing, he's going back there?
That's correct.
Yes,
Oh.
yes. This kid is a delinquent kid.
Well, we haven't talked about anything yet. We haven't talked about anything yet. I don't even know that he did. I haven't seen him since yesterday.
Well, he'll be in court, what, tomorrow, the next
Yeah, he'll
day?
be in tomorrow.
Is he on the docket for that, Jonathan?
Yes.
I know,
Okay.
sir.
You're going.
Did you want to say something, Jerry?
I don't want to. I want to go home with my mom, please.
Well, again, and let me get the substance of what he did for, because the officer knows.
So, I get a call from Mrs. Cook, and Mrs. Cook, as you know, is an elderly lady. She implied to me that she has Jerry, also Jerry's friend, over sometimes to mow the lawn. He was just over a few days ago and did a horrible job with our lawn. And I guess he decides to play a prank on Miss Cook. And he basically asked for the lady of the house, and when Miss Cook answered the phone, she says, "I'm the lady at the house." And then there was a lot of laughter, she recalls, and then she recalls that Jerry called her a hoe.
Okay. So you charge Jerry with delinquency by reason of lewd and obscene
Absolutely.
calls?
It was a lewd call.
Yeah.
So you spoke to Mrs. Cook? It was you who spoke to her?
Yes, I spoke to Mrs. Cook.
How did she know it was Jerry?
Mrs. Galt, I can't hear you.
She knew it was Jerry because, as I finished saying, that Jerry had been doing some yard work for her. And she knows that Jerry had just been over a few days ago, so she recognized the voice.
I know, but a number of the kids in the neighborhood all work for her. Since she lost her husband, the kids all go over and ask if they can do chores. I mean, this is over
Yeah,
the
but
phone.
she's been doing various work. Jerry's been doing various work for her, along with others, and everyone has their distinct voice. With the hearing of the giggle, he has a certain laugh.
It's all right, Mrs. Galt. Jerry will have a hearing. He'll come to
Yeah.
court and
I don't want to
we'll
leave.
decide.
I know, but he's 15 years old. He's being kept in a detention
We
center.
can't leave. We can't have delinquent kids out on the
Yeah,
streets.
yeah, we have to make sure he comes to court for the
It was
hearing,
only a
so.
phone call.
Oh, so you did make a phone call?
No, but I mean, even if I did do it, so you can't keep me away from my family. I
That
don't
may or
wanna-
may not be so. It depends on what happens at the hearing.
When is the
Okay.
hearing?
Tomorrow, officer?
It's
Yeah,
tomorrow.
yeah. The officer will bring you in tomorrow, and then the court will decide,
Yep.
and we'll go
Take
from
it
there.
from there.
When was it going to be notified about the hearing? My husband's out of town on business.
You would have been notified, but we had to take him off the street. That's the most important thing.
Or are we going to talk about what actually happened yesterday? Because so far, I
Not today, not today, no.
You're just going to keep him overnight, and we're not going to talk about who did what?
That can happen tomorrow at the hearing.
He's 15.
Yeah. Mrs. Gall, with all due respect, I have children before me from ages 7 and up that commit offenses. And it's the role, my role as juvenile court judge is to do what's best for them, as well as the officer looks out for what's best for them as well.
Why did you
Joe?
have to be taken off the street?
What's that?
Why did you have to be taken off the street? It's just a phone call. It's not a violent offense.
Jerry was told that he needed to stay out of trouble.
Okay, I'm sorry, I'm not going to discuss the substance of it today. Officer, you have your job. If you, Mrs. Galt, want to say goodbye to your son, you'll see him tomorrow.
Oh, my God.
No.
May I say one other thing? So he's going back to this detention center today where there are probably people who have done much more significant things, and he's going to be in with this group. Isn't it better that he
Some
comes
better,
home?
some worse, and they're all children that, receive services, and that's what the nature of this court is. As you know, because your son does have some prior involvement with this court.
He was only
Right.
with that other boy. He was not accused of doing
Okay,
stealing.
the court will hear all of those things tomorrow. Jonathan, would you please escort everyone out? Thank you.
Follow me.
Right?
So, Joe, I thought you were going to play the pissed off brother. That you were mad. You were too pro-Jerry. So there could be really some fireworks in
When I
the...
looked at the facts, I thought I had seen that.
Okay, that's fine.
He had repeated that he had murdered his brother, but maybe I'm confusing that with my other role with the dad. I got confused because I think the dad defended him. So.
And Laura, you were great as the mom, but don't forget that the mom also kept asking, "Where's Mrs. Cook? Why isn't she here?" etc. But that was funny that you also, all of you, took the made-up facts that I gave you and brought that into play as well. So again, we don't know what really transpired in Mickey's chambers, but it wasn't much, in terms of, well, it was much in terms of violation, right, of Jerry's rights. So what was the violation? What were the violations? Let's list them again. I know that we went through golf the other day. I'm sorry, Amanda was going to say something.
Wouldn't it be like notice to his parents of what's going on?
Okay, so the notice. So remember, Laura asked at one point, "What? I didn't get anything in writing. What's my, so no notice both to Mr. and Mrs. Galt as well as Jerry. Okay, and that's because why? Why does he have to have notice, Joe?
That is a notice.
Because why?
Because of the Fourth Amendment.
What's his right? What right are we talking about? Procedural due process, right? Life, liberty, property. So what right are we talking about? Liberty, right. Well, how is his liberty right at stake?
Taken off the street.
Yeah, exactly. Exactly. And then eventually detained for a much longer time than just the overnight. Okay.
Court equated it to being equal to a felony.
Correct. Correct.
That process.
Yes, absolutely. So what else? And you know what? Nobody said anything about lawyers. I thought you would all be clamoring. Oh, I thought one of you would be clamoring, or even you, Jennifer. Where's my lawyer? How come I don't have a lawyer? And then I would have said, oh, well, the officer is here for your best interest. I'm the juvenile, nice, motherly judge that wants to do what's best for you, etc. Because that was the rationale before Galt, right? So right to notice, right to counsel. What else is missing here? What are the other two?
Right to
Confrontation.
So confrontation. So Cook's not there, and Cook, she may not have to be there. If this was really an arraignment, she wouldn't need to be there, but there'd be other questions. And you guys brought up, you said as Jerry, Jennifer, why can't I go home? And the court didn't at all get into, when you're arraigned, it's not the trial itself. It's not whether you did it or not. It's what you're going to plead to. If there's a question of jury trial, are you going to elect jury trial? And then most important, is the court assured, if you are let go at that point, that you will come back for your next court hearing. So question of bail becomes, your connection to the community. Mrs. Galt would be saying, and that's what we're going to do for the next hearing. Mrs. Galt would be saying, well, he lives with me. I'll make sure he comes to the next, court hearing. He's in our custody, et cetera, et cetera. As well as, so the question of bail goes to not only, are you here? Are you likely to flee? And also the nature of what you allegedly have done. Picked up the phone and made a lewd phone call. He didn't allegedly kill anybody. much later on when we get into the delinquency and youthful offender cases, that would be a huge question if allegedly a juvenile had committed a more dangerous offense. So not only would that be brought up at a bail hearing, but there would be most possibly under 58A a dangerousness hearing, as well. But that's talk for later. Incrimination, and what's the last right? I'm sorry, Jennifer. Self-incrimination. So we kept getting Jerry to admit, and at one point you said something about, and I said, oh, so you did pick up the phone, right? Okay. All right, who do we have as players for the, now everyone will pretty much stay where they are, because you're assuming now I'm on the bench as a judge, and we're going to do the arraignment. And so I've got Amanda, I don't have a pen with me, but Amanda S. We have two Amandas in here, guys. Amanda S. and Amanda P., right? So Amanda S. Is the district attorney, so you'll play a very large role in terms of the
So what is he actually
in terms of the arraignment.
Just
so
remove phone calls?
yeah, delinquency by reason of because you're in juvenile court. So Amanda's the DA. I've got John this time playing Jerry. Okay. Amanda P. is Mrs. Galt. Okay. Joe, Mr. Galt. So you guys would have brought him, let's assume that after arrest he was let go. So they brought him in, not the officers, all right? Okay. Yes, okay. But still, you may want to argue something at bail, maybe not, okay?
Didn't it say that he was let go? That then there was no indication as to why?
Yeah, you're looking at the actual case.
Right.
Yeah. So what we're doing now is if the actual case is heard today, the arraignment. And so, Michael, your officer flag, and Jim is not here, and he would be Officer Henderson, which is fine. Michael, why don't you come and sit up here? What? As well as Jennifer, because you're the probation officer. And Laura, you're the clerk. Stephanie, you're not here for the arraignment. You'll be here when we do the next piece of it, okay? Jonathan and Nicole, you guys both represent Jerry, all right? Do you all know what an arraignment is? You can stay where you are, or actually you could sit next, if you feel free to move around and sit next to who you need to sit next to, client, etc.
Oh, yeah.
Laura, why don't you come over here?
I'm Officer Flag. Jerry's over there. Jerry's John.
John is Jerry. Nicole and Joe. Yeah.
Joe is the parent.
Wait, what?
Wait, no.
Okay.
Wait, me and Jonathan.
Joe's the dad.
I'm sorry, Jonathan.
She's the attorney.
Yeah, Nicole and Jonathan, you're both Jerry's attorneys. Yeah. I know.
Where's Mrs. Galt?
Miss,
No.
Oh, he's Amanda.
yeah. So parents brought him in. Okay. I think I need the attorneys closer to the client, and also.
Wait, who's left? Who's Jen?
Where is the client?
It's John. Stephanie, move down.
All right, so parents,
Yeah.
Jerry, the two attorneys.
Yeah,
What's
exactly.
Stephanie playing this time?
She's not. She's Mrs.
I'm
Cook.
not playing yet, I'm cooking
She's not playing yet.
You can just throw my stuff.
later. I'm Mrs. Cook later.
Amanda, are you okay over there, or do you feel do you need to be more in front of the court as a district attorney? You can move if you want. No, you need to be in front of me. You need to be facing me.
Oh, all right.
Okay.
I'll move down one.
Okay. And actually, you
We should
pretty much have no role because it's the arraignment.
Right.
You would have given the paperwork, the police report to.
To both sides.
Yeah, yeah. We'll talk about that in 1 second.
Actually, this is
Do you want me to the regular, what Joe, what
You'll
John
call,
intended?
yeah, but you'll call the case in a different way.
Yeah, there's no.
Did you get my email that I was going to?
Yes, no problem.
Make sure you got that.
So, one thing I want to talk about, a few things preliminarily too. So, Michael here is Officer Flagg. He really has no role in the arraignment. I had him sit up here anyway. He would have had the police report, and he would have supplied the police report to counsel for Jerry. And of course, the district attorney already would have had the police report. If he was bringing him in, it would have been a different, sort of role. Jennifer, other than she's sitting in probation office, which is somewhere, to the side of the bench or whatnot, really, may or may not have a role at arraignment. It depends on what the district attorney, where'd you go, Amanda, is asking for in terms of bail. I might want to look to you for his record, and or later when we do the third hearing, if we get all the way to disposition, then again the court would be looking, to you as well. My clerk here is Laura. She's going to call the case, and then she'll take notes after that. Once the case is called, I would be hearing from Amanda first as the district attorney. Actually, counsel will first introduce themselves. So Nicole and Jonathan for Jerry, Amanda for the district attorney. I'll also ask, so in the courtroom would have been, Mr. and Mrs. Galt, who I don't know, and your client, Jerry. So I'll ask who they are. They could, I may or may not address them. Even though it's a formal setting, you'll begin to see in this course that the juvenile court is much more, right, Nicole, informal than some of the other trial courts, and it is because of the parens patriae, philosophy of the juvenile court. So I may ask you, Amanda, to summarize the the alleged facts as it ties into, what he's been charged for. He's not admitting to anything today. He's with counsel. He got notice. He would be electing today whether he wants a jury trial or not. You'll find out later on when we get to delinquency that even though the U.S. Supreme Court had found that because of the nature of the juvenile court, the juveniles actually do not have the right to jury trial, Massachusetts, again, gives more rights to juvenile, and by statute he actually has right to jury trial. So he would be electing or waiving his right to jury trial. If he waives the right to jury trial, again, it's a waiver, and I want to make sure it's a knowledge, intelligible, etc. waiver, and he's with counsel and he's with his parents, so that shouldn't be an issue. So you guys can decide whether you're going to do that or not. It's just an acknowledgement today whether you're going to go to the jury session, which in most of the juvenile courts is in the same court, and it's usually 1 week or less out of the month that those same courts are juries that sit to hear the cases. What else? Am I missing anything in terms of arraignment? His plea. I'm sorry.
Should we say juvenile? Are we not supposed to use his name?
Okay, good question. Actually, that's what you can do, Mike. You're the officer, right? So, Amanda, you'd already be sitting in this session. So the juvenile session is a closed session. The parties would actually be out in the hallway. And I know that not all the courts do this, and they should, in terms of granting privacy. When the kids come in the building, they're supposed to go sign in with probation. They're actually assigned a number. And when the clerk calls the list in the morning, and just the attorneys are in for the call of the list, they're also designated, which courtrooms to go to, and what the number of the case is. So let's assume you're case number 3. So you're going to be going in the hallway. You're going to say, in case number 3, come on in, and mother, father, and Jerry would be coming in to sit down. Now, counsel for a child might already be in here. If you had a case in here right before saying number 2 was your case. Or you might be in the hallway talking to Jerry anyway, and you're going to come in. So, yeah, however you want to do it. Yeah, you guys don't have to get out and leave the room, but I do want you to go through the exercise of sort of going over there and saying, hey, come in. Because once he does that, then you'd be calling the case, Laura. Attorneys would be standing up to introduce themselves. Does that answer your question, Amanda? Okay.
And so in Massachusetts, they're identified by a case number. I know, like in Maine, they use just first name, like first.
Within where? No, again, we're within a closed courtroom. I've got the case file. The case file itself that the interested parties can get is, Commonwealth versus Jerry Galt. But say,
No,
I'm sorry.
I mean, like in the lobby, like so.
Yeah. Oh, okay.
They'll come out and say, Mason H.
Okay.
Something like that.
Yeah. So it's a way to sort of, preserve their privacy. No member of the public can go into the clerk's office. Say one of Jerry's. Suppose Ronald's parents wants to see Jerry's file, or somebody else, a neighbor or something, or a law student or another lawyer, okay? You can't go into the clerk's office and say, I want to see the file in Commonwealth versus Jerry Galt, and pull it, because you're not an attorney in the case, you're not a party, they're private. If it was Superior Court, District Court, Land Court, Probate and Family Court, they're all open to the public. Okay, so only cases concerning children are closed to the public, and that's the reason for the closed sessions. When I started practicing, we didn't have a separate juvenile court building. We went to the local district courts, and it was just one of the sessions was designated as the juvenile session. And it was tough because, the kids were all out in the hallway mixing with, with the adults, and that's when, you did hear case names and things like that.
And now in Massachusetts, is 18 the cutoff, or did they do an earlier cutoff?
Well, brand new law as of this summer. So some of my materials that you might have on the CD says the jurisdiction of the juvenile court, for delinquents are 7 to 17. It's now 7 to 18. Okay, so we will be talking about that later on. All right, ready?
Yeah.
Okay.
Guys, do we do the OA?
No, just Commonwealth versus. We're quick and to the point.
Okay. So I wait until he brings them in.
Yeah.
Could I please have case number 3 in courtroom 2? Case number 3, courtroom 2.
Okay.
Judge, we're announcing the case of Commonwealth v. Jerry G. Attorneys, please stand and introduce
You
yourself.
say the whole name.
Oh, you are.
We're within the closed session now.
Okay, Commonwealth versus Jerry Galt. Attorneys, please stand and introduce yourselves.
Amanda Sennett, counsel for the Commonwealth.
Good morning, Nicole Grimes, representing Jerry Galt, who's present in the courtroom.
Good afternoon, Jonathan Etes, representing Jerry Galt as well.
Good morning. Good morning. Who else is in my courtroom?
Jerry.
To reintroduce them.
Okay.
Your Honor, this is also Mr. and Mrs. Galt, Jerry's parents, who are present as well.
Good morning, Mr. and Mrs. Galt. Good morning. And here from the
Oh, and
Commonwealth?
his brother, too, so. No, that's not.
No, it's just the parents.
They changed.
Ms. Sennett, Attorney Sennett?
Yes. So here, a complaint was filed against Jerry on the day of June 8th. His neighbor,
What's he charged with, counsel?
he's being charged with delinquency by reason of lewd telephone call.
Okay. Is there a question of bail?
There is question of bail.
Would you like to be heard?
Yes.
Go ahead.
The Commonwealth will be requesting $2,000 bail for Jerry.
A counsel for the child? Would you like to respond to that? Either one?
To the bail?
Actually, has probation taken a financial intake?
Yes, we have. That $2,000 seems fine for the bail.
The family has the ability to pay
Yes.
such a high bail for
Yes.
a child?
Yes.
Okay.
Commonwealth could consider if there's means in which the family cannot pay it, depending on certain facts.
Your Honor, our client is being charged with a...
By the way, assume every time you speak, you don't have to do it, but if you want to get in the practice of doing it now, you stand up.
Your Honor, our client is just being charged with lewd phone call. I don't really see how such a high bail is really necessary. He's not really a risk. His parents have both agreed that they would, take care of him in their own custody and make sure that he was able to, stay on a curfew and make sure that he stays out of trouble at home. So we think it would be more sufficient for our client if he goes home with his family rather than staying in a detention home on such high bail.
Mr. and Mrs. Galt, do you have anything to say? Tell me, either one of you work. What's the status at home? How many other children do you have? Mr. Galt, you can start.
I travel for work, so my wife does the job of taking care of the kids. My older son's currently at home. He helps take care of Jerry. And
Mrs. Galt, do you work during the day when Jerry's in school, or?
Yes, I work a part-time job from 9 to 1.
9 to 1. Oh, so you are home when he gets home from school?
Yeah, I'm
Okay. I don't have a problem to having him released on his personal recognizance.
Thank you, Your Honor.
Okay. What's the plea for the child counsel? Not delinquent.
Your Honor, we plead that that Jerry is not delinquent in this matter. There are several issues as far as him being charged with being delinquent. One issue being that the complainant in this
That's
case,
fine. The court doesn't need to hear that today at arraignment. Is your client electing jury trial?
Yes,
Okay.
we are.
Okay. And you're looking for a motion date? Ms. Grimes? Attorney Grimes?
Would I go with the August 17th one?
What's that?
Would I go with the August?
No, here we are, January, so I would be saying,
today.
August.
So today then. Okay, so yes, Your Honor, we're looking for January. Today's what? 29th? January 30th, 2014.
Laura, could you look on the wall where the calendar is?
Yes.
How does that look?
Judge, that looks open.
Okay. Attorney Senate, is that date fine with you?
Yes, 2 o'clock, that seems fine.
Mr. and Mrs. Galt, you can bring Jerry in on that date?
Yes.
Or either one of you, actually. I know that you travel, Mr. Galt, and you have expressed, obviously you're here today, an interest in your son. Jerry? Good morning.
Morning.
Have your attorneys explained to you that you have the right to have the Commonwealth prove its case beyond a reasonable doubt, and you do not need to do anything other than sit in court?
Yes, they were very clear about that.
That you don't have to testify if you don't wish to testify? Okay. And today I'm letting you go home with your parents. I know that you've had some trouble in terms of probation before, and you are still on probation. And actually, the probation, my probation officer here is being very generous with you, because she has not filed a violation of probation on you, although she has the right to do so, because this new charge brings obviously a violation of the probation that you're under currently. And so I'm depending on you. The court is, probation is, your parents are. To stay out of trouble until your next court hearing, to go to school every day. Will you do that, Jerry?
Yes, thank you, Your Honor. I'll be better.
Okay. So you're going to say the next day and say, Patty's are free to go.
Okay.
This case is continued to blah, blah, blah.
So this case is continued until January 30th at 2 p.m. tomorrow. And until then, you're all free to go.
Actually, yeah, it wouldn't be that quick for your motion date, but that's fine. All right, any questions? So it's quick, you're not arguing the merits at the arraignment, so the arraignment is for certain purposes. It has to do with that notice. You got the notice that he did something. He gets counsel that from right from the beginning is appointed for him. Court is concerned whether, is he going to come back for the next hearing, is concerned with, is he on probation, etc. The issue of jury trial. Jonathan?
So You said that the notice was given. So at the arraignment, is that something that we would argue if his liberty was taken away prematurely without notice? Is that something that we could argue at arraignment, saying, okay, you know, the parents, his liberty was taken away before the
Certainly say he was, as in the real case,
right, so that would
just
be done.
grabbed and held. Although, again, in Massachusetts, there are instances where, for example, when a kid is picked up, they are supposed to follow the statute, and it involves, you know, notifying parents if parents aren't around, notifying the probation. You know, so let's say that it shouldn't happen. It may happen.
So
Do you follow me?
No,
what I'm saying? Yeah.
So say if it does happen, like if you know, if that statute.
It's conditions under which the child is detained. So he might have been detained. Say he was, you know, arrested at the other end of Massachusetts, right? His parents were called. They didn't pick up the phone at 2 a.m. Probation was called, and Jennifer said, yeah, I have an outstanding, you know, he's under probation in this court, blah, blah, blah. No, I shouldn't say the other end of Massachusetts, because it would be a different county. That just messes up the hypothetical too much. Bottom line is going through all, but even when they're detained, they're not detained somewhere where adults are as well. They would be in a juvenile shelter or some part of this whole statute on all of those procedures. So chances are what you're bringing up is, at least in Massachusetts, is not going to happen, right? And that's mainly because of the Gall case and because of the way that courts and case law and statutes have followed suit after that, okay? All right, so let's get to the real fun part, the heart of it, the trial. So how do we want to do this? Let's, everyone can sort of stay where they are, I think. So what we're going to do is obviously a piece of it, because, you know, maybe Jerry would have testified himself. There might have been some other evidence. The only thing we're really going to have time for is the direct and cross-examination of Mrs. Cook, which is the right that was, you know, violated in the real Jerry Gall case. Stephanie, why don't we have you maybe sit on the right side of the room where everyone can see you better, and that way, I don't want her that close to Amanda, because I want Amanda to be able to project when she asks her questions. Do you know what I'm saying?
Okay. So just to get this right, this is the defense team, Commonwealth, but she's going to sit over there.
Yeah.
Okay.
Yeah. So she's on the witness stand, okay?
Do we?
No, maybe right over there.
Right here?
Yeah, yeah. So you would have been these guys would have been sitting sort of more in back of me, and you would have been actually closer to the judge's bench, you know, as the witness. So let's assume that the Commonwealth just, you know, we did opening statements already, and the Commonwealth now is putting on its first and only witness. Do you want to just start?
Yeah.
Or do you want, actually, I'm going to have Laura swear her in.
Tell the truth, the whole truth.
Yeah, that's all you have to say.
Mrs. Cook, do you promise to tell the... Do you still be...
I wish the online students could see Mrs. Cook right now, because she's really assuming the role.
She is. Put your left hand on the Bible, please. Do you
Actually, no, Laura, we don't have Bibles in court.
Do you promise to
Sorry.
tell the truth, the whole truth, and nothing but the truth, Mrs. Cook?
Say it one more time.
Do you promise to tell the truth, the whole truth, and nothing but the truth, Mrs. Cook?
Yes.
Thank you.
Hello, Mrs. Cook.
Hello.
Go ahead.
Good afternoon, Mrs. Cook, Amanda Senate, Council.
Wait, stop for 1 second off the record. Now, remember, if she asks any question that you can object, and if you want to object, just stand up, and as you're standing up, just say objection. And once you do that, obviously, both should stop. It doesn't always happen with witnesses. If she already has said the answer, it wouldn't be an objection. It would be what? You want to strike the answer if it's, you know, if you haven't said it quick enough, or if they're too. All right? Okay.
So good afternoon, Mrs. Cook. My name is Amanda Sennett, counsel for the Commonwealth of Massachusetts. Can you please state your name for the court and spell your last name?
Aura Cook. That's not Aura as in, it's Aura. Aura Cook. C-O-O-K.
Thank you. Now, Mrs. Cook, who, if anyone, has helped you tend to your property and the needs of your property at your home since the death of your husband?
Wait, off the record, actually, what's your objection? You're objecting.
Wasn't that a double question?
Or what might be another?
Narrative? I don't know.
Compound.
But what else? All I heard was her name, and all of a sudden she's saying something about her dead husband.
You want to say it?
Todd?
Relevancy?
Yeah, she hasn't laid the background, the foundation. Okay, all right.
Okay.
You want to get her to say a little bit more about? Ask where, you could ask where she lives, what she
I'm really
does.
sure, like, if I can get into that, or we're just.
Yeah,
with this.
yeah.
Okay.
Remember, you want the witness doing all the testifying. So you ask, who, what, when, where, how, those sorts of questions, so that she is telling the story.
Okay.
But not so much that she's following into a narrative either, right? Okay.
So, Ms. Cook, who do you live with?
I live alone now. My husband, he passed away about a year ago.
A year ago. I'm sorry to hear that. So, now that your husband's gone, there must be certain chores around the house that maybe you have trouble doing by yourself?
Objection.
Leading.
Yeah, sustained.
What normal chores do you do at your house every day without help from anybody else?
Objection again.
What?
It's a leading again, no?
Okay, sustained. Stand up next time, Council.
Okay.
I don't know. Should I answer that?
When she says sustained, it means to proceed, right?
No, it means that
to be rephrased.
Yeah.
Rephrase? Okay.
Yes.
Mrs. Cook, sometimes, and I know you want to tell your story, but it has to be told in a certain way because we're in court, so that when the district attorney asks you a question, you do your best to answer truthfully the answer to that question. But should one of the other attorneys stand up, that means that they're not really at you for that. They're objecting to the form of the question. Your attorney has to ask it in a certain way to meet legal requirements. So if you would just stop talking when any of the attorneys stand up, that would be great. Okay? All right.
So, since the passing of your husband, what chores have you had to now take on in the house?
Well, I could still make my bed, and I cook a little. I had oatmeal and applesauce this morning, and I can still do things around the house. I actually still drive too.
Good. What are some of the things that your husband would do to tend to the house and the property?
He pay all the bills. I wouldn't have it no other way. And well, I did all the cleaning. Sometimes he'd cook for me, but I could cook myself, Well, he did do the lawn. Yeah, and he fixed things around the house every now and then,
And that
He was a good man.
Seems like it.
Yeah.
So, are you capable of mowing the lawn? Do you mow the lawn?
My arthritis won't allow me.
So your lawn just goes unmowed, or do you have help come in?
I have
Leading. Objection, leading.
I'm going to let that one go. You can answer that, Mrs. Cook.
I have a few neighborhood kids. Jerry was one of them, yes.
And they help you? Oh, go ahead.
I'm going to help you right now.
Okay.
She just said Jerry. What should you say next?
And Jerry, is Jerry here in this courtroom today?
Okay, yeah,
Can you-
he's right there.
How many times a week would Jerry come to your house and help you?
Well, see, that depends. Now, the lawn just gets done once a week, and sometimes he wouldn't come over too often, but he definitely come over every week. And sometimes he and his friend, I don't remember his name. Ronald.
Was he another neighborhood kid?
Yeah, I think they're friends, Ronald Lewis. Yeah.
And
They
they
come over and, and sometimes Jerry sit down with me and have a cup of tea.
Oh, he did.
Yeah.
So you guys had more of a personal relationship versus him just
Absolutely.
coming over and mowing the lawn?
Absolutely. Yeah.
Okay. Did you ever have to call Jerry to come and mow the lawn for you?
Jerry would really be anxious to call me, really. So he called, need lawn mowed. Yeah. Yeah.
What happened on the day of June 8th?
Excuse me?
What happened on the day of June 8th?
I just remember getting a call from Jerry, because like I said, he called me. And this time, Jerry sounded a little different, but I could tell it was Jerry because he laughed. And he said, "May I speak to the lady of the house?" And I said, "I am she, the lady." And then all of a sudden I heard two voices just cracking up in the background. And I said, then they say, "You the lady?" And then they call me hoe. She a hoe. And I said, "Oh my goodness, they called me hoe."
Is there anything else that they said to you on the phone?
They said, "We're not gonna hold the lawn.
They said, we're not gonna hold it.
We're not gonna hold
Gonna
the
hold her
yard.
yard.
I think it's the lawn or the yard. The lawn or the yard. I think they said the yard. We're not gonna hold the yard. The yard.
Yep, we're not gonna hoe her yard.
Yeah, we're not gonna hold the yard."
Is Jerry and Ron the only person that mows your lawn?
Well, when they're sick or they gotta go do something else for their parents, I have another boy come over.
Another childhood? Another child in the neighborhood?
Yeah, they all go to school together. Yeah, but it wasn't him. It was Jerry. It was definitely Jerry.
Was it the voice on the phone, or was it the remarks that were made on the phone that led to you believing it was Jerry on the other end?
Objection.
Leading.
Yeah, sustained.
No further questions.
Okay, cross. You could each take a turn if you want. Whatever do.
Good afternoon, Mrs. Cook. My name is Nicole Grimes. I represent Jerry Galt. So you had mentioned earlier that your husband would take care of the outside, necessary chores, the lawn, fix things around the house, right?
Yeah.
Okay, and then you also said that Jerry kind of took that over after your husband passed away.
Yeah.
Okay, and you also said that Jerry comes over about once a week to do the lawn.
Yeah.
Right. So how well do you think you know his voice from once a week?
I know his voice.
Stop! You went too far. You were doing great. Now you gave her a chance to explain.
Oh, wait, can I strike my own thing?
Let's see. What would you have said? Go ahead. What?
I know his voice because, as I said, he stopped over to have a cup of tea.
Okay, so can we definitely strike that one?
Keep going.
Okay.
Good.
Just screwed yourself.
Well, every other one or something. Okay.
Can we? I don't think we can do that.
Can we do that? Every
Tag team
other?
across examination.
Can we tag team on it?
Why don't you sit down and let Jonathan answer?
Okay.
I'm sorry, ask 4 or 5 questions. And
So can we go backwards?
you can do whatever you want.
Mrs. Cook, you had stated that that Jerry and his friend would come over to do yard work. Is that correct?
That's correct.
And you had also stated that you received a call on June 8th. Is that right?
Yeah.
And you had also said that the voice on the phone was different from Jerry's voice. Is that right?
I didn't say that. I said I could tell it was Jerry, but he sounded a little different. not the voice was different. He made his voice sound a little different, but I could tell.
You have stated that there were 2 individuals on the phone. That's right.
I just said after he called me a hoe, I heard people laughing. I heard 2 people. It sounded like 2, yeah, sound like 2 giggles.
But
It was just 2.
there was actually nothing that was said over the phone that would indicate that it was Jerry. Is that correct?
Yeah, well, when he said in the beginning, it's a lady, and now I speak to the lady of the house, and I know that was Jenny.
You
At that point.
had stated that there were several children that would help you out around the house. That's correct?
No, I didn't say several. I said there was another person when the boys weren't available.
But it's fair to say that everyone in the neighborhood knew that you were the lady of your house. Is that correct?
I don't know.
So when the callers asked for the lady of the house, it's fair to say that that could have been anyone. Is that correct?
Oh. I don't know. Can you understand the question?
So your testimony is today that you don't know if that could have been Jerry on the phone. Is that correct?
No, I'm pretty sure, Jerry.
But there was nothing that was said on the phone that would implicate Jerry as the caller. Is that correct?
Just his voice, but he had a little different in the voice.
So your testimony today is that the voice on the phone was different from Jerry's voice. Is that correct?
It wasn't different from his voice. He just made his voice sound a little different. You understand, young man?
No further questions.
Mrs. Cook, can I ask you a question?
Yes, ma'am.
So Jerry, he came to your house by himself. Now, I know that you've testified that he comes weekly and you pay him and you pay others, other children as well, right?
Yeah.
But he came to your house one week after you had surgery totally on his own. He fed your cat and he gave you tea, isn't that right? That was a pretty nice thing to do,
Yeah,
right?
he's nice.
Yeah.
That's
Oh,
nice.
okay, all right.
Yeah. Well, I guess kids will be kids sometimes.
This a witness that just doesn't let go. Do you have any other questions?
No.
Redirect? Okay. Thank you, Mrs. Cook.
Can I leave?
You can leave. That was great, Stephanie.
That was incredible.
Really great. Really, really good. And it's tough getting a witness like that because you guys on cross were asking, the form of your questions were fine. They did call for a yes or no answer. And what you could have done sometimes, where she just kind of didn't answer yes or no, you could ask to strike or ask to, strike the rest of her question after such and such, because she tended to want to explain, and that's like the death knell of the cross-examiner. And I thought that for your first time too, Amanda, you got into it. Anybody have questions? So, okay, Michael and then Stephanie.
So, as the defense attorneys, would you try to discuss like how Ronnie sounds on the phone and maybe how she could tell the difference between their voices? To indicate maybe it wasn't Jerry that made the actual
that
remark.
might be, They also have, don't forget they have information, and I think, I don't know if, I guess what the court ended up hearing, it sounded like Jerry called her a lot. But that's not what we have. We have that he would pretty much, he just lives down the street, he would show up. So I would have maybe really tried to get at that. He doesn't really talk to you on the phone that much, so therefore, again, you don't want to go too far so that she says, of course I know his voice, but to create enough of a doubt, right, that she really doesn't know his voice on the phone. Joe?
Also, to create doubt, just bring into account her age and maybe she might have hearing issues, because a couple of times on the stand she had said, "Excuse me, I didn't hear that," and just try to harp on that, just to maybe create the idea that she might have
Yeah,
misheard.
it does say that she
Right.
does not wear hearing aids.
She doesn't.
She does not.
That she does not, but
That's
she,
the only
yeah,
way
yeah.
glasses.
She also says that, we also know that she does drive, but only grocery store and doctor. So maybe she goes to the doctor for him, I don't know. I don't know if that's something, it really depends. Notice that I interjected, just ask a question too. Again, it's still the rules of evidence, but juvenile court judges do tend to do exactly what I did, so that's why I wanted to, again, in the interest of the best interest of the child, even though it's a adjudicatory, criminal proceeding. And of course, Jerry would have had the right to testify, but depending on whatever the trial strategy of the defense, he doesn't have to. Same burden of proof in Ray Winship was a U.S. Supreme Court that was decided burden of proof is beyond a reasonable doubt for the adjudicatory delinquency proceedings as well. So the Commonwealth would have had to prove beyond a reasonable doubt that that it was Jerry who violated this law of committing an obscene phone call. But that wouldn't be the end of it, right? Because in the real case where Jerry was sent away for what? Till 2021 or whatever, the court would then be looking at, okay, he did it, but let's now look at his situation here, right? In terms of and you tried to mention it, Jonathan, at the arraignment, in terms of the type of offense. It isn't such a serious offense. Yes, he has a prior, but even the prior itself, even though he was on probation, again, was on something not, so serious. He's still very young. He lives with his parents. Maybe we'd hear also about his schooling, is he a good student, et cetera, things like that. He's not going to get commitment, even if the Commonwealth had proved this case beyond a reasonable doubt. He wouldn't be committed like Jerry Galt was committed in the real case. He might still be adjudicated delinquent, because the Commonwealth has, if the Commonwealth has met its burden of proof, but he could still walk away and go home with his parents with conditions. Did you just have your hand up, or was Michael?
Yeah, I did, but I think Stephanie.
Oh, Stephanie, I'm sorry.
I wanted to ask, as attorneys, what happens when, there are obvious facts that were given prior to this hearing and or this trial, and what happens in the case of the witness facts contradicts with what is already in statement? Like, for example, I said he called. I knew that Ms. Cook didn't make a call, but I changed it to he called me so I can recognize his voice. But what happens?
That he called you before.
Right.
Yes.
So what happens in conflict? Because I kind of just did that to see if they would pick up on that and to kind of shut it down, because that's not what the facts said prior.
I think, couldn't we
So
have
what
done,
happens?
couldn't we have done to go up and show a past recollection recorded, what she had already said before to refresh her memory?
Well, there's nothing on the record when you, oops, I just caught my necklace. This isn't a case where something was submitted in evidence, right? So for example, if it was if it was a care and protection case, and you've got the 51A and the 51B reports already in evidence to set the stage for the abuse and neglect, and social worker is on the stand, and maybe she's forgotten, a visit with the family or something like that. Her attorney, which is DCF, could try to attempt what Amanda just did, have her recollect from her social worker notes. Another thing, if it was a different sort of situation, it could go to what's called impeachment, all right? But you don't have that. The only evidence we have is what she has said, what she's saying now in this court. Even though there was a police report, the police report isn't in evidence. And even if we had Flagg or Henderson on the stand, it would be hearsay, because they would be saying, well, Mrs. Cook said, and you guys would be on your feet jumping up and down. saying that's out of court statement, right?
Right, 'cause
Yeah.
there were more than, there were several
So-
other kids in the neighborhood, and I
Yeah,
just said,
yeah.
there's one other person.
Yeah. So, I mean, it comes down to the, you're a witness, the court is observing your demeanor, and it's the discretion of the trial court judges, believing you, or disbelieving you.
Okay.
Or if Jerry did take the stand, again, observing his demeanor as well, believing him, disbelieving him, etc. Yeah, Nicole.
I have a quick question. When I go into the Lowell Juvenile Court,
Nicole is interning for an attorney that is an alum, a past alum from years ago, great attorney Anna Elliott. Actually, you're going to read one of her cases in which she was a trial attorney later on. The starts with a W, and I forgot the full name because it's not the real name like they do in the. But she had challenged the juvenile curfew in Lowell, and actually filed a motion to dismiss on constitutional grounds, and everybody hated her for it. But anyway,
What was the
she's
outcome,
getting.
Professor? Did she prevail?
Oh yeah, the SJC found that the curfew was unconstitutional. It's I'll remember it. It's in your materials. It starts with a W much later on in the delinquency cases. Nicole, so go ahead. I'm sorry. I wanted to set the background. So she has a great internship.
sometimes Judge Flynn, when she's on the stand, they'll, the attorneys will go back and forth, objection, hearsay, and it's clearly hearsay. But she'll say overruled.
Yeah.
Is that allowed?
Well, did you notice, Jonathan, at one point you objected, right? And what did I say? I want to hear it. What did I say? I said I want to hear it. It was a valid objection. I should have sustained it, and I didn't. And that also happens a lot.
You have that discretion, though, right?
Well, I mean, I'm supposed to follow the rules of evidence, but, actually a good friend of mine who also practices in juvenile court, and she's a defense attorney, who also should be a stand-up comedian, but she has what's called the "this is nonsense" objection, and it has worked. But she knew she needed to object to something, and the nonsense objection, and your Honor, Your Honor, it's a nonsense. Is that the basis for your objection? Anyway, so it's the juvenile court. Again, think of it as it's come through the years from 1899 on, and you already read some of the early cases, and you'll read more of the early and the later cases. And so you've got, on the one hand, adversarial proceedings, counsel, all these due process rights, but then on the other hand, you have that it's the whole reason for the court is because kids and adults are different, and that we should be looking at, all in all, the best interest of kids. So that's why I said to Jonathan, I want to hear it, even though it was a valid objection. Yeah, and you hear that a lot. Yeah. Mm-hmm.
Every objection is overruled.
Yeah.
It depends on the attorney, though.
Yeah. Mm-hmm. Yes, Michael.
I haven't had evidence yet, so I don't know whether
That's
this
okay.
is, against the rules or not. But when she said something about boys being boys, at that point, could the defense attorney say...
Stephanie said it?
Yeah.
Okay.
Couldn't they say, isn't that exactly what this is, just boys being boys? This really wasn't,
Oh, as a next question?
He really isn't a delinquent. Don't you think he's a good boy? He comes and helps you out. Don't you think this is just sort of an isolated,
Okay, so Nicole's going to answer that?
But she's not exactly like an expert to say what a boy does. Isn't that kind of just her giving her opinion?
You're saying Stephanie said
Yeah,
boys being
Mrs.
boys.
Cook said it's just boys
it wasn't a
being
Amanda in a
boys.
question, right? Okay.
No, she answered it, I think, to one of the defense's questions.
Yeah.
So what is, it's on cross-examination.
And so at that point, I was thinking in my head, wouldn't you jump all over that saying, isn't that exactly what this is?
Well, you could have, remember the question I asked? Yeah, you want to be careful also that, that on cross-examination, that you're keeping it as the attorney doing the cross-examination. It's sort of professional and objective, and you're not, antagonizing the witness, especially in juvenile court where you have a lot of child witnesses, for example, witnesses like Mrs. Cook. So hearing that, why not the next question have been, that's right, Mrs. Cook, boys are boys, and didn't, then come into the question that I asked you about. And Jerry is a good boy, isn't he? He's come to your house on his own. He's fed your cat, right? He's given you tea. Yeah, so don't give her the chance to explain that or to fight with you about that. You always want to ask a question, if you're in cross-examination, that you definitely know that they have to either say yes or no back to you. If there's any chance that they're going to explain it away or that they're going to fight with you about it, you want to back off.
I was always taught by Anna that if you say, don't you think, the boy, isn't that an opinion though? That's an opinion and the other attorney can object to it.
And you don't want to ask, don't you think, anyway. What's wrong with that? Especially on cross-examination, don't you think calls for what kind of an answer? An explanation. Why do you want the witness to explain? You want the witness to either admit to what you want them to admit to, or to agree with you that such and such is, that it should be a no answer. Todd is an online student. I'm sorry I didn't introduce you.
Nice to see you again. Hello to everybody online. Wanted to add, I was in court on Monday. Got the opportunity to observe an OUI here. It was actually a trial.
Adult or juvie?
It was an adult trial. But what I wanted to add to the discussion was that the line of questioning from the defense attorney was, he was asking one of the arresting officers, he was a field training officer.
Okay.
He was asking about what had occurred.
Okay.
And the officer said that they stopped giving chase to this particular vehicle because it was going the wrong way on Route 95. And their protocol was to stop. And the officer said, it was apparent, he said, we stopped because someone was going to get killed. And the defense attorney stood up and said objection, and the judge overruled it. And I think what you're saying is, and I think the other students in the class are asking, it straddles the line of whether it's personal observation or conjecture. And in that case,
that's right,
because the judge overruled it and let him say what he wanted to say, it was his own personal opinion. So I think some of the students that are asking that, bring up a really good point, but you'll get the hang of it where it's either conjecture or their personal opinion.
Exactly. And think of the reason for why a witness is testifying, because that particular witness has heard, has observed, has been involved in something in which, a regular witness, not an expert witness, right? In which he or she can testify about.
You really want to limit your questions to closed-ended questions. Yes,
if you're cross-examining, absolutely. Yeah. But see, the important thing is here, not that I'm teaching you guys evidence, because I'm not an expert in that, but I'm teaching you about juvenile law, which in many respects is very similar to adult law, and then in many other respects is different. So I think I sent you, did I send you an email with what we're doing, the exercise we're going to, so I want you to read the cases, but we're probably going to start right in with the exercise. So read the cases knowing that I'm going to put you into roles, right, to be using the cases to be making an argument, whether you're a student or a principal or a parent or whatnot. Okay? All right, I'll see you Tuesday.